Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 145 of the Business SOS podcast. Thank you for listening, supporting me for the last, not going 2.5 years. Very excited so as to continue my goal to episode 200. So today we're going to talk about something a little bit different. This one, the theme is I lost my case, what next? Yes, sometimes you lose cases. I've been in both ends of the spectrum. I've been in the winning side, I've been in the losing side. And if you talk to an attorney who tells you they never lost a case, I don't think that's true. They have not had challenging cases. The reality is when you go to court, as I have mentioned before, there's a degree of unpredictability. You are putting your entire legal problem in the hands of a jury that for the most part does not want to be there. If you've been called to jury duty, you don't say, I'm excited to go. You don't want to be there. That's the reality. But people serve and they do their job. Or in the hands of a judge who has a ton of cases, sometimes over 1,000 cases to manage, and the judge dedicates 1 day, 2 days for your case, or whatever the number of days that the case may require. And the judge is the fact finder in this case. It's what is called a bench trial. And then the judge will determine that. So you're putting your entire case in his or her hands to determine your future. And in trial, there will be a winner, there will be a loser. There's no draw here. And a decision will be made. So sometimes people lose cases. And I want to talk about that. What happens or what to do if you lose your case. And so say, this is a bench trial, for example. You go through your trial. You had all your depositions taken. Let me backtrack a second here. You have your depositions taken. You have to go through your trial strategy with your attorney. You go to mediation, which is mandatory. The case just doesn't settle. Lately, I'm finding out that some cases are just not settling. They're going to trial. And there might be a number of factors here. Perhaps it's because the Supreme Court in Florida created a mandate that cases have to be resolved in 12, 18, or 24 months. So there's a sense of urgency now to resolve cases than before. Cases could go on for 3 to 4 years. It's actually good that now there's a specific timeline that the cases must be resolved by. Perhaps it's because of those deadlines that are more compressed than before. Cases are now going more towards trial, not settling early on, which is fine. It's just the way it works. So you go to your mediation, it does not get resolved. You do your pretrial stipulations, as we talked about a few prior episodes. You have your deposition designations. You're ready to go. You have your bench trial. Takes 3 days. You go through your discovery. You go through the presentation of evidence. And then, a few days later, sometimes the judge renders a decision there. Usually what happens are two things. The judge either tell both sides, send me a proposed order. And then you have to send a proposed order with the findings of facts, conclusions of law of what you believe your case, the judge should rule by, based on the evidence that was presented in the case. In essence, you are retrying the case in paper again. And I've done that as well. It's just quite a bit of work getting your transcripts, and you got to almost convince the judge this is the way you should rule. The other side will do the same thing. So both sides present proposed orders to the judge for the judge to rule upon. It's one way, but they'll delay the case perhaps about a week or two simply because it takes so long to prepare those proposed orders. The other way the judge could handle it, has happened now a number of times with me, is that the judge says, okay, I have the evidence that I need. If there's any supplements, he'll give you maybe 2 days to put any supplemental evidence that you want to provide, something that perhaps it was not included in the initial packet. And then the judge will render a decision. renders a final order on the judge on the trial. So you have your final judgment. The final judgment includes, again, the findings of facts of the case, conclusions of law, the verdict, whether it's a plaintiff verdict or defendant's verdict. If it's a plaintiff's verdict, it means that you won something. You're the plaintiff, or the plaintiff won. Where it might be money, might be some type of equity, might be whatever the case. Let's talk about it might be money. So the judgment is the amount of damages that he or she will award the plaintiff, their prejudgment interest, and whether or not he grants attorney's fees. Usually those are reserved for another hearing, but he said you're entitled to attorney's fees. We'll reserve that for another motion. And then the judge signs the order. This is your final judgment. Your attorney receives that via email. You open it, you see it, and then the attorney sends it to you, tells you the bad news. We lost the case. It happens. Okay? So you have a number of options in this case. Okay? You obviously want to find out, obviously, you want to read the opinion of the judge and then, ask your attorney, okay, what can we do here? Depending on the amount, you have a number of options. Okay? Find out whether there's an issue that the judge perhaps did not agree with your version of the events. It's really more of a fact question, a fact issue, that the judge saw the facts differently than you believe the facts were. Perhaps the judge did not believe some of your witnesses. Perhaps the judge believed the other side's witnesses. What evidence was presented, what evidence was admitted. So your attorney has to do an analysis about what happened in the case and what could have been done differently, but you're not going to retry the case. But it's always good to learn what happened and perhaps anything that could have been done differently, because it is fairly unpredictable what's going to happen at trial. You have your presentation of evidence. Someone may object to the evidence, or perhaps a question that you may ask. And it is a process that of a degree of an unpredictability. But that's the system that we have. So you also find out whether or not it's a procedural matter, whether something that should have not been admitted was admitted into evidence that it was your attorney objected to, or perhaps something that a witness that was not allowed to testify for whatever reason. You got to find out what happened. Once you've made that determination, an attorney can explain to you what happened, why the judge entered this ruling, because it'll be explained in the order. Then your option, you say, what is next? What can I do in this case? Okay, you have a number of options. Okay. The first thing is to explore whether or not you can appeal that decision. The decision is appealable. So you can appeal, and I'm probably going to bring an appellate attorney to here to talk to us as well. But we're going to give you kind of an overview. Okay, you can appeal a final order, whether if it is a error in law that the judge made a mistake, or the judge abused his discretion. So 2 grounds. So, and there's timing issues here. Usually what happens is that within 15 days of that final order, final verdict that is, or final judgment that is entered by the court, there's a motion for rehearing that is given to the judge. You have 15 days to do that. And again, I want to make sure this is not, I don't want to take, in the case it's your case, you need to get an attorney. This is not legal advice for your case. I'm giving you more of an overview of the timing here issue. So I just want to clarify that. Usually within 15 days, you can file what is called motion for rehearing and tell the judge why he got it wrong. Judge is human. He can make a mistake. And the reason for that is that you give the judge an opportunity to perhaps correct the record and reconsider his ruling at that time. The other side will perhaps file a response in opposition to that rehearing, say, no, you got it right. Obviously, they won the case. They want to make sure that the judge doesn't change his mind. In these cases, the judge doesn't have to have a hearing. The judge can just look at it, either agree or disagree. The judge will enter an order. It is difficult to get the judge to change his mind. I just want to be clear with that. But it's a shot. If you don't ask, the answer is no. You go ahead and do that. And I believe it is a requirement before you file an appeal because it tolls the time for appeal. And again, if you're in a situation that you're appealing a final judgment, you got to get an attorney. I want to be clear with that. So the judge signs that denial, said, motion rehearing denied. And then at that point, you have the option to pursue an appeal or not. Usually, what your counsel will do is hire an appellate counsel that specializes in doing appeals. And there's a decision that has to be made here. And a question that has to be made. A number of questions. Number one, do you have a copy of the transcript of the trial? And that is important. If you do not have a trial transcript, it'll be impossible, nearly impossible, to file for an appeal. Because what the appellate court does, they look at the record, at the entire record of the case. You got to index it. It's a very time-consuming task, and for the appellate attorney, and an appellate attorney looking at this for the very first time wants to know what happened at trial. So if you're in a situation you're going to trial, you have to get a trial transcript. It's highly recommended that it's not required to get a court reporter, but it's highly recommended you get one simply because if you do not, you're not going to be able to preserve the record for appeal. So it's extremely important to do that and discuss it with your client. Sometimes you can work out a deal with opposing counsel and say, hey, why don't we share the cost of the trial of the court reporter and share the cost of the trial transcript if we order it. That way, one side doesn't have to bear the brunt. You can work that out. I don't think I've worked that out with the opposing counsel. It's worked out well, simply because you both need it anyway. So I pay twice. So it is an option that you have, but it's highly recommended to have a court reporter at trial. So they look at the trial transcript. They also look at all the discovery that was done in the past, look at every single aspect of this case. So you can imagine the thousands of documents that this appellate attorney has to review in order to determine whether or not you have a good grounds for an appeal. Maybe it might be an admission that was not taken into consideration. Maybe it was testimony that was excluded or objected to, and the judge sustained an objection when it should have been objected to. So the appellate attorney will look at that and will determine whether or not you have grounds for an appeal. Most likely, you'll have to pay for that consultation with the appellate attorney to make that evaluation of the case. If you decide you want to go the appellate route, be prepared to pay a lot of money up front. I've seen retainers of $20,000 up front to begin an appeal, depending on the case. And the reason for that is that most of the work for the appellate work is done at the beginning of the appellate process. It's what is called the appellate brief. You're the one making an appeal for a ruling that the judge made or a final judgment. You want that to be reversed for certain grounds. The appellate attorney has to do the brief right at the beginning and then submit that to the appellate court, depending on the Florida jurisdiction you're in, or any jurisdiction. So that appellate brief takes a tremendous amount of time. It's highly detailed, very precise, and that costs significant amount of money. So it's a calculation you got to make whether you want to appeal it and what are your chances of success on that appeal. And the appellate counsel can tell you, you have very solid grounds because of X, Y, and Z. And then you got to decide, okay, is it worth it for me to continuing this or looking at other options? Now, a question that I get often is like, if I appeal the case, will that stop them from collecting from me? So let's talk about that. Okay. When you get a final judgment coming to you, you're going to be, as part of the final judgment, you're going to have 45 days. You're going to be ordered by the court within 45 days to provide a fact information sheet. We talked about that perhaps a few months ago, that I went through both of them. The fact information sheet is the form 1.977A for individuals and form 1.977B for businesses, depending whether you have the final judgment as an individual or for a business. So that fact information sheet you're going to provide is going to fill it out under oath, and you're required to provide financial statements, tax returns, bank statements to the winning side. And the objective is to assess your financial status, but also to begin to collect on the judgment, to satisfy the judgment. So the answer is, if I appeal this ruling or the decision, can they stop collections? The answer is no, unless you post a bond with the court. So say you have $100,000 final judgment against you, and you want to appeal that decision. You have to post a bond of $100,000 with the clerk of the court and as security to stop any collections effort. Unless the opposing side agrees not to collect while there's a ruling, 9 out of 10 times, they're going to say, no, you want me to stop collecting, you got to post a bond. Otherwise, we'll pursue it. So what happens if you don't have the money to pursue an appeal, or you just say maybe an appeal is not warranted, or perhaps the chances are you're not going to prevail at appeal after the appellate attorney goes through the analysis? What options do you have? You can negotiate. One thing that you can do is negotiate perhaps a lesser amount, because all they have is a piece of paper with a judgment, and it's a good piece of paper. As a judgment is good for 20 years. They can continue attempting to collect from you for 20 years, ask you financial statements, go for your bank accounts, garnish wages, make it very, very miserable for you until they satisfy the judgment. And also that shows up on your credit report as well. An option you have is try to negotiate a lesser amount, whether it's a payment plan schedule or perhaps a lump sum for 80%, whatever amount it is, but you can negotiate a lesser amount to be able to satisfy the judgment. Your role is to go ahead and try to get rid of the judgment through some type of negotiation and payment, so that way you can move on. A third option that might be, and I remember having my friend Jeff Tromberg, I believe last year, here, he's a bankruptcy attorney. We talked about that. The third option is to consult with a bankruptcy attorney about whether or not bankruptcy may be your option to get rid of the judgment. And it might be, that might be an option for you. And usually when a client of mine is in that situation, I present all the options, including discussing this with a bankruptcy attorney to see whether bankruptcy might be an option at this stage. It may not, but it doesn't cost anything to at the very least explore that option to determine whether or not it might be a good idea. And there are different areas of bankruptcy, whether it's reorganization or liquidation, is simply another option. And the plaintiff knows that. The plaintiff knows that there's always that possibility that they obtain a judgment, the judgment will be incollectible. That's always a possibility, because in order to collect, you need to have the final judgment. That doesn't mean automatically you will convert that final judgment into money. It means you have the ability to collect to satisfy the judgment. And they want to collect as fast and efficiently as possible without spending more money. In your case, you want to pay the lease to satisfy the judgment. If you're not able to do that, then bankruptcy may be an option for you after you consult with a bankruptcy attorney. At the very least, explore that option. And in some cases, not only you get rid of that debt, but you get rid of any other debt you had before as well. And you can have a fresh start. So, losing a case is not the end of the world. It's not pleasant for sure, but it's a moment in time. And there are options that can be had. You can actually have options to try to resolve the matter. You can sell some assets. If you have them, you can borrow from a friend to get to satisfy the judgment. There are many different options you may have to try to get rid of that, but the reality is it's there to stay unless you do something about it. So if you're in that situation that you actually lost the case and have a final judgment, don't ignore it. Don't give up. Don't think that's the end and then just let them collect over and over again. At the very minimum, during those first, you immediately, if you're do this on your own, say it's a small claims case, you lost the case, or a county court case, or you're doing this pro se, which now I see more and more people going pro se with the assistance of ChatGPT or other systems, other AI models. If you're in a situation that you went pro se and then you had a final judgment, you have to get an attorney immediately. Because what happens is that you miss certain deadlines, you cannot make them up. You cannot make up those deadlines. So it's always good to consult with an attorney who understands litigation to help you with this. So you have negotiating the final judgment, looking at a potential appeal, also bankruptcy as a third option, if it's available after consultation with a bankruptcy attorney. But it's not the end of the world. But the key here is that you have to immediately take action so you don't miss those important deadlines to appeal. Usually it's 30 days after the final judgment. That's what you have to appeal, to file notice of appeal, to preserve your rights. If you miss that deadline, it is gone. You cannot do it at the 40th day, 50th day, it's pretty much gone. So now, a final judgment, one more point I want to make, it's good to have somebody look at everything, because you might have, once felt safe that you might have one more Hail Mary, is whether or not, if you're in the defense side, which in this case you would be, if you lost a case, money collecting from you, it's whether or not you were properly served. So you got to go back to the very beginning, whether or not you were properly served. Because if you were not properly served, that might be grounds to vacate that judgment. So there are a number of options available here. Okay, but the important thing is to get the attorney to help you analyze what happened. I think this one is a short one, so it'll be no, one more point I want to make. Yes. Two more points, actually. You have a final judgment, you have assets, okay, to protect. I recommend in this case get an attorney who specializes in asset protection to guide you what assets are protected, which assets actually are subject to collections. So an asset protection attorney will be able to help you with that. I will discourage you and I'll advise you in this one. I will actually give you advice. Don't start transferring your assets to somebody else to avoid the creditor. I'm going to repeat this. Do not begin to transfer your assets to somebody else to avoid the collection from the judgment creditor, the one that won the lawsuit, the plaintiff. Okay, that's what is called a fraudulent transfer. In Chapter 726, we have fraudulent transfer acts. So if you start transferring your money to a friend or somebody else to try to avoid them collecting from you, they'll collect from them. So they have the ability to collect from whomever you transfer the money to if you did it with the purpose of avoiding creditors. So you got to be careful with that and not do that. Throughout the lawsuit, or you might be able to, but you will have to consult that with an asset protection attorney to help you whether or not that is an option. But I will discourage you from transferring any assets with the purpose of avoiding creditors, because you can be subject to further sanctions, penalties, and also whomever you transfer the funds to or the asset to also will be brought into the lawsuit. So I'll discourage you from doing that. It's not a good idea. This is good for today. The key here is to be prepared, be informed, and call an attorney to help you if in the case that you lost the case. If you have any questions about anything I talked about today, I know it's kind of a complex subject, not an easy one to explain. My email is rich@richsierra.com. My phone number is 866-842-5202. My website is floridasmallbusinesslegalcenter.com. You can follow us in Facebook at FSP Legal. If you want to see the video of this podcast, we're at youtube.com/@RichardSierra. Don't forget, check out my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.